Hello, everyone. I'm so glad you're here. My name is Krista Kartson. I'm the Senior Director for Sponsorship Initiatives with Welcome.us. This event is hosted by Welcome.us, and we are a nonprofit, non-government organization founded in 2021 to empower and equip Americans to participate in the work of welcoming newcomers, primarily through private sponsorship. And this is our live monthly webinar, which we call Welcome.us at the Table. We've designed the space for sponsors and welcomers who care about private sponsorship pathways, the newcomers we've welcomed, and the stories of welcome that unite us. Today's webinar will explore the topic of sponsorship in the news. And we'll take the next hour to focus on recent headline policy changes relating to newcomers, how our guest speakers have seen these policies impact communities, and tools for navigating the present uncertainty. We will dedicate a significant amount of time today to hear from our Senior Policy Counsel and Special Advisor, Manpreet Teji, and our expert guest with us ASAP. Her name is Lady Perez, and she'll join to answer your policy questions. Throughout the webinar, we'll be answering some questions in the Q&A function as well, and that's located at the bottom of your screen to the right of the icon that says chat. We won't be able to answer case-specific questions today, but we'll do our best to point you to the right resources using that Q&A function. And before we share policy updates, it's truly an honor to introduce sponsor Kim Snellgrose, who is here to ground us in the realities of how recent policy changes are affecting American communities. Kim is a wife, mom, certified public accountant, and adoptive parent whose heart for Haiti fuels her work in sponsorship and now in her advocacy on behalf of the Haitians she sponsored. Kim, welcome to the table, and thank you for joining us. Would you share more about your story? Why did you sponsor your Haitian friends through humanitarian parole, and what challenges is your community facing given the recent changes in policy?
Thank you for having me. So I first met Kevin Sin in 2019 while doing mission work in Haiti. I was very quickly impressed with Kev, who at that time was a homeless high school graduate who had taught himself English by watching YouTube videos as a way to develop a marketable skill. After developing a trusted friendship, Kevinson became a full-time employee of our mission. And because of his frequent visit to banks and ATMs and money transfer facilities, he became targeted and robbed at gunpoint. And we knew that because he had been targeted and identified as a person with access to financial resources, that he would continue to be targeted and no longer would be safe in Port-au-Prince. The CHNV parole program was truly a godsend for us as it allowed my family and I an opportunity to provide safety to our friend when we knew that none could be found in his home country. We count ourselves very lucky that Kevinson and his fiancee Shirley's parole was approved in June 2023, just a very short 6 months after the program was enacted. After arriving in America, Kev quickly went to work bettering himself and his situation. Part of this process included attending classes and receiving his truck driving certification and CDL license, an opportunity that truly never would have been available to him in Haiti. I will never forget the celebration that we had with Kev earlier this year on March the 10th, when he was given his very own big rig and a route to drive on his own. We went with him and we celebrated this opportunity that he had in this access that he had now been granted and earned. This truck was representative of his hard work, of his dedication to improving his life, and represented an access to a new level of financial resources, which would have never been imaginable to him. This excitement was soon squashed when Kevinson received his CHNV termination and self-deportation notice on March 28th, just a short 18 days after he began his career. This was a new blow after he had just been feeling this new level of hope and security that he had never felt. The termination just felt all that more bitter. Kevinson and his fiancee Shirley moved into our small Texas town and quickly became fixtures in our community. And they never missed a Friday night football game. If you live in Texas, you know how important that is. Um, they were at all of our community block parties, became members of our church, and became friends to coworkers. Our community support organization earlier this year organized a pickleball tournament and raised all the funds that Kevin Shirley needed to pay their legal fees associated with their asylum case. And while we were excited about this and thankful for this, it was also another form of disappointment for Kevinson, as he had intended on saving his earnings from his truck driving career and really wanted to pay those legal fees on his own. We have been very blessed to receive national media attention on Kevinson and Shirley's case. And this attention has allowed even quiet members of our community, people who intentionally avoid political discussions, it has provided them an opportunity to share their voice in support of their friends. Kevinson and Shirley have truly humanized immigration in our community to the level where it is no longer a debate. It is a clear humanitarian crisis impacting real people. I am often, and I know many of you who are sponsors are probably asked why you would open your home to foreigners. And I feel like the answer for me and for all of us is the same, and that is, why not? If I have the capacity and access to resources, why wouldn't I share them? And as an American, I recognize that I am born into privilege. And this is not a privilege that it is mine to flaunt or to glorify, but one that I feel that I and we all are called to use in service of others.
Thank you so much, Kim. Thank you for sharing your story. And as you shared, it's not just yours, it's the story of your community of humanity. And I know that it resonates with so many in our audience who are also navigating the impending loss of their friend's status right alongside you. So thank you for raising your voice. Thank you for sharing and what you and your community are doing. In such a time as this of deep uncertainty, your story reminds us that we're not alone.
Thank you.
And sponsors like Kim are why we do what we do here at welcome.us. You are why we strive to accurately interpret new policies as they come out and continuously develop updates, Q&A, and guidance materials to help welcomers navigate this road ahead. And that's why we've also launched welcomer communities in some of our most active states, which you'll see on the screen here. Just as Kim shared about her community, these communities connect sponsors like Kim and welcomers like you with each other for the purposes of sharing information, building connections across our shared value of welcoming, and coordinating to raise awareness. Our welcomer communities offer monthly Zoom meetings where you can come off mute, unlike in this space, and actually speak with other members and raise questions about what you're facing as a welcomer. Community members also connect via WhatsApp so that you have an entire network of support right at your fingertips to exchange information about local events, resources, and even encouragement, because we all need it. In our next webinar speaker, Manpreet Teji, joined the Welcomer community meeting in Ohio just last week to share similar updates, as she'll give us in just a second. I was also on the call as a sponsor, and it was a great opportunity for folks to ask her questions directly and have a really robust dialogue about the on-the-ground realities of what we're experiencing as sponsors versus what we're seeing in the immigration headlines. These groups have been a long time coming, but we've seen Just a tremendous importance in launching them right now at a time when we're needing to navigate multiple policy changes. We're seeking opportunities to amplify our value for welcoming, like Kim's community is doing among our local and national leaders. And we're feeling more fractured and isolated as neighbors, and these connections are things that bind us. This is the time to come together in community and across political divides to foster honest and meaningful connections around our shared work. So in the post-event survey and email, you'll have the chance to sign up to learn more or participate in a welcomer community if you live in one of our active states that you see on the screen here. So please stay tuned for that. But without further ado, I'm going to go ahead and turn the mic over to our colleague, Manpreet, to share the latest sponsorship-related policy updates with us.
Hi, everyone. It's so good to see you all. Thank you so much, Krista. Before we begin, I just want to remind you all that we will have some time for an extended Q&A after our expert speaker presents, and you can submit your questions in the Q&A function, which is to the right of the chat icon. So I wanted to start off with the biggest news of the month. On 4th of July, President Trump signed H.R. 1, the Budget Reconciliation Bill, that's also referred to by his administration as the Big Beautiful Bill. I'm going to review the 3 most relevant impacts to newcomers, but you can find a more thorough overview in our new policy explainer, which we are dropping in the chat right now. First, the law imposes new fees for immigration applications, such as employment authorization and asylum. For example, applying for asylum now costs $100 plus another $100 for every year an application is pending. Applying for temporary protected status, or TPS, will cost $500 rather than the previous $50. Applications for work authorization for asylum seekers, TPS holders, and humanitarian parole recipients will now cost $550. TPS holders will also have a shortened eligibility period, meaning they will have to reapply for work authorization every year and pay an additional fee application each time. These new fees may directly financially impact the newcomers you've sponsored, so we encourage you to take a look at our policy explainer if you're working with a newcomer right now to apply for an alternative legal status or work authorization. We will continue to update that explainer with relevant information as implications of this new policy unfold. Another major impact on newcomers and immigrants is the access to public benefits that they have been previously eligible for. So the law excludes resettled refugees and asylees who do not have yet green cards, TPS holders, asylum applicants, and most humanitarian parole recipients from eligibility for Medicaid, Medicare, the Children's Health Insurance Program, also known as CHIP, and the Affordable Care Act marketplace. Only green card holders, Cubans and Haitians who entered the United States through humanitarian parole, and specific Pacific Island communities remain eligible for healthcare benefits. The date of revocation of access to healthcare services varies by programs. Healthcare access via Medicaid and CHIP will be revoked on October 1st, 2026. Healthcare access via the Affordable Care Act will be revoked January 1st, 2027, and healthcare access via Medicare will be revoked January 27th, 2027. Additionally, the law excludes refugees, asylees, and other newcomers from receiving food assistance through SNAP. Only green card holders, Cubans and Haitians who entered the U.S. through humanitarian parole, and people residing under a compact of free association are eligible to access or continue accessing SNAP. Federal guidelines allow up to 4 months for states to implement SNAP eligibility changes, and current SNAP recipients will likely see the impact of the changes at their next recertification. I recognize this is a lot of information at once, so I strongly encourage you to see our policy explainer, which outlines the programs revoked and their respective deadlines. Finally, the law includes $126 billion for border and immigration enforcement, including $59 billion for customs and border protection personnel, vehicles, and facilities, and $45 billion for family and adult detention. The increase in funding for immigration enforcement will expand the government's capacity to detain newcomers who have recently lost status, including sponsored newcomers. Newcomers whose primary status is terminating should consult our guide to navigating alternative legal options and seek legal counsel immediately and carry appropriate documentation, including a signed Form G28, which can be used to show that you are represented by an attorney. We'll share the link to show an example of the Form G28 in the chat, which should be completed and signed by the newcomer's legal counsel. I recognize we've shared a lot of information at once, so I want to take a moment to highlight one of our newest resources designed to guide sponsors and newcomers through steps to consider in the event their humanitarian parole status is terminated or expires. The goal is to help newcomers think through decisions they may have to face and develop a plan. As you can see on the screen, this resource includes considerations for newcomers who arrived through Uniting for Ukraine and the processes for Cubans, Haitians, Nicaraguans, and Venezuelans, and is available in English, Ukrainian, Russian, Spanish, and Haitian Creole. I encourage all the sponsors of newcomers who arrived via these pathways to take a look. I want to end on a bit of a hopeful news for us before I hand it over to our next guest speaker. Reception and Placement, which is a federal program that offers resettlement services such as housing, case management, and cultural orientation, has resumed for Afghan individuals with special immigrant visas. This means that SIV holders can apply for RNP services within their first 90 days of arrival in the U.S. through their local resettlement agency. If you are a sponsor of an Afghan newcomer who arrived within the last 90 days, we encourage you to contact your local resettlement agency to confirm availability. RNP through a local agency may be available as a supplement to the tremendous support you're already providing as a sponsor. We're dropping a link in the chat now for a list of affiliated organizations and contacts to get started. I recognize that is a lot of information, and I'm sure that you have many questions about the status of alternative legal options. That is why I'm honored to welcome my dear friend, Lady Perez, to the table to offer an expert review and answer some of your most common questions. Lady, would you like to start off with introducing yourself?
Thank you, Manpreet, and hi, everyone. My name is Lady Perez. I'm the Policy and Communications Director at ASAP. I first started at ASAP in January of 2021 and was here until March of 2022 when I left temporarily to go work at the White House. I came back in 2023 and have been with ASAP ever since. So I wanted to give you all a little bit of a brief overview of ASAP so you all know who we are. ASAP began as an all-volunteer effort in 2015, and we were incubated at the Urban Justice Center in 2016. We became a standalone nonprofit organization in 2019. ASAP's first 5,000 members were mostly Central American mothers who crossed the Mexico-US border, and they charted a path forward that would lead to ASAP's explosive growth. We now have over 700,000 members. In 2020, these mothers organized and voted to bring a landmark lawsuit, winning quicker access to work permits for ASAP members. These founding members chose to open ASAP's doors, and membership numbers have since skyrocketed. Their continued advocacy ultimately led to work permits being available sooner for all asylum seekers, regardless of ASAP's membership.
Thank you so much, Lady. ASAP has done such truly incredible work, and I'm so glad we could partner today, and I'm so glad you could join us. Many sponsors and welcomers in our audience are navigating the changes in legal status for the newcomers they sponsored. So before we dive into the alternative legal options for these newcomers, can you just remind folks what exactly is humanitarian parole and why newcomers may have to apply for another status in the first place?
Of course. So humanitarian parole allows people to temporarily enter the United States due to some urgent humanitarian reason or for significant public benefit. For many decades, the US has used humanitarian parole as a way to protect people facing humanitarian crises around the world. As this group, I'm sure, well knows, parole has been used, for example, to provide protections for Ukrainians that were fleeing war or people escaping violence in Latin America and Afghanistan. People who enter the US on humanitarian parole may end up having to apply for alternative status, which we'll get into a little bit, if the parole program in which they entered is terminated or if their parole status expires without being able to renew that status. One of the alternatives for people from a qualifying country is called temporary protected status, or TPS. Another possible option is asylum if the person is fearful of returning to their home country because of either past persecution or fear of future persecution.
I see. So you just mentioned temporary protected status, which is one of the primary alternative statuses that newcomers in our community are considering or have considered. So can you explain what TPS is, why it exists, who is eligible, and what the current state of TPS is?
Sure. So temporary protected status, which you'll also hear commonly referred to as TPS, is a form of status granted by the executive branch, specifically by the Secretary of Homeland Security. And TPS allows for people from countries that have been designated unsafe for reasons such as natural disasters or political instability to live and work legally in the United States. TPS is granted for a period of 18 months, and the government can renew it at its discretion. So TPS provides people with three main benefits during those 18 months. The first is that they're eligible for a work permit. The second is they're eligible to re-enter the United States if they travel internationally, so long as they have obtained authorization prior to traveling. And the third is that they're authorized to remain in the United States as long as their country of citizenship maintains this TPS designation. It's really important, though, for me to note that TPS does not provide a pathway to a green card or US citizenship.
Thank you. So what would make a newcomer eligible for TPS?
Yeah, so a person from a country that has been designated this term unsafe that I said before because of a natural disaster or a war or is eligible for TPS if they were present in the United States at the date designated by the federal government. So the US government designates TPS countries and dates retroactively so that it does not create an incentive for people to come to the US. So, for example, the original TPS designation for Ukraine was effective for Ukrainian citizens who arrived in the US as of April 11th, 2022, but it was not actually announced until April 19th, about a week later.
That is helpful. And as we can tell, there's a lot changing with TPS, including which countries are designated for TPS and when those protections are valid until. So I know a lot has been changing up until even today. So can you tell us which humanitarian parole sponsorship countries have TPS currently?
Yes, of course. So there are currently 20 countries that have TPS, though many of those designations have been terminated. So the TPS for the following countries have been designated recently, and I see we have it up on the slide. So for Venezuela, the 2023 designation was terminated, and the 2021 designation is valid only through September 10th of 2025. For Afghanistan, it ended on July 14th, but I wanted to flag that there was a recent court order that paused that termination for 7 days. So in short, what happened was that a judge in the Court of Appeals granted an administrative stay for 7 days, which pushed the termination of TPS for Afghanistan until July 21st, while the parties briefed the case. So we should have more of a conclusive decision after that. The third country is Haiti. It was announced to be ended early and will end on September 2nd of 2025. And the fourth country is Nicaragua, which is ending on September 8th of 2025. And currently, Ukraine has a TPS designation that is valid through October 19th of 2026.
Thank you. And what are the chances, in your opinion, of renewal or new TPS designations?
Yeah, so to date, President Trump's administration has not renewed any expiring TPS designations, and it has not issued any new TPS designations, and it has not expressed any plans to extend or to issue new TPS designation. So we're not able to know for certain what the administration plans to do because this is, of course, dependent on country conditions.
So many sponsors in our audience have supported their newcomers in the process of applying for TPS. And the common question we hear about is employment authorization, if it will work for those with pending TPS applications. Can you speak a little more about the pending work authorization piece?
Certainly. So people with an approved Form I-821, which is the actual application for temporary protected status, are able to obtain work authorization. In the vast majority of cases, people will apply what's called concurrently or at the same time for both that TPS designation with Form I-821 and the application for a work permit, which is Form I-765. So then when USCIS approves their TPS application, it could then approve their work permit application. And up until a few weeks ago, work permits for people with TPS were valid, for the duration of that TPS, so for 18 months. However, as you mentioned at the top of the call, recent changes that were passed by Congress through the reconciliation bill have now limited the validity period of work permits for people with both humanitarian parole and TPS. And those work permits will now be valid only for 1 year. So this means that people with TPS will have to reapply for a work permit every year and to pay that additional $550 every year to obtain the work permit until their TPS ends.
I see. So another common question that we get is, as it relates to TPS, the TPS application is, especially in light of the increased ICE enforcement I spoke about earlier and the more funding that has gone towards ICE, is if a pending TPS application or approved TPS status are considered protection against detention or deportation.
Yeah, so TPS status, once it has been approved, has traditionally come with the protection against deportation. However, a pending TPS application unfortunately does not offer the person the same type of protection. So as we have seen enforcement being ramped up, it's unclear how or whether it will be the case that someone on a valid TPS status is protected from being detained by ICE in the future.
Thank you. As you've shared, TPS is a temporary status and is ending for many of the newcomers in our sponsored community, unfortunately. The other primary alternative status that we've pointed to for months is asylum. And given the founding understanding of ASAP's work, I think you're the perfect person to talk to us about this today. Can you give us an overview of what asylum is, who can apply, and what it provides for those who are granted it?
Yeah, so I'm going to try to dwindle this down. There's a lot of information here. So asylum is a form of immigration status for people who have already come to the United States and are afraid of returning to their country of origin. So if an asylum seeker is granted asylum, the United States government cannot deport them. Because of their well-founded fear of persecution, it's unlikely that their home will be safe enough for them to return for the foreseeable future. So unlike parole or TPS, asylum does include a pathway to permanent residency and citizenship once a person is granted that asylum status. So how do you get an asylum approval? Asylum seekers must show all of the following 4 things. The first is that they have to have been harmed in the past, or they have to have a good reason to believe that they will be harmed in the future in their country of origin. The second is that this harm has to be because of a specific characteristic, like the person's race, religion, nationality, political opinion, or something else about them that they cannot change or should not have to change. The third thing is the government of the country of origin will cause this harm, or the government will be unable or unwilling to protect them from this harm. And then the fourth thing the person would have to prove is that they would not be safe if they moved to another part of their country of origin.
Thank you for this extremely, extremely thorough overview. I know it's a lot to cover in just a short, short minute. I know I mentioned earlier that there are some new fees outlined in the budget reconciliation bill that impacts many immigration applications. Is asylum included in that category?
Unfortunately, yes. So prior to July 4th of this year, when the president signed the reconciliation bill into law, there was no cost to apply for asylum. However, that has since changed or is in the process of changing. The reconciliation bill added a new $100 fee to apply for asylum and a yearly $100 fee for every year that an asylum application remains pending. It can take many years for an asylum seeker to receive asylum approval. Many of our members have been waiting for over 5 years and sometimes even longer for their interviews for their asylum approvals.
Thank you. So while applicants are waiting for their asylum approval, are they eligible for work authorization? And if so, how does this process work?
Yes, they are. Asylum seekers can apply for work authorization while their asylum application is pending. So asylum seekers can request an initial work permit 150 days after submitting their asylum application, and they're eligible to receive that work permit. So USCIS can actually send it their way after 180 days after filing their asylum application. So the government must make a decision on an asylum seeker's initial work permit within 30 days of having received the work permit application. However, as we all know, that this does not always happen. Additionally, on July 4th, there was a change in the fee for initial work permits for asylum seekers. So prior to July 4th, when the reconciliation bill was signed into law, asylum seekers did not have to pay any fee to apply again for that initial work permit. Now, asylum seekers will have to pay a $550 initial work permit fee if their work permit application is based on that pending asylum application. Really important for me to note a few things. This $550 fee is unwaivable. It is in addition to other fees authorized by law, so DHS could always increase it, and it also is going to adjust according to inflation. So as of October of 2023, asylum seekers have been receiving work permits that are valid for 5 years. Thankfully, the reconciliation bill did not change that. However, the bill did add a new $275 work permit renewal or extension fee. And again, this fee is unwaivable, which means people cannot get fee waivers for this. It's in addition to other fees authorized by law, and it's going to adjust with inflation. So we anticipate that because of a lot of these changes, it's going to take the government much more time to renew work permits for asylum seekers, and that waiting time is going to continue to increase. It's currently taking, just so folks know, about upwards of 10 months for most applicants.
So you've mentioned a lot about how this bill is affecting the asylum process, and thank you for that thorough analysis. Are there other trends in asylum that ASIP is aware of, such as policies impacting the asylum application process?
So yes, by law, people with pending asylum applications cannot be deported. However, the administration has been moving to close certain asylum applications and has been putting those individuals in something called an expedited removal proceedings, which is a fancy lawyer way of saying a quicker way to be able to deport asylum applicants. A few weeks ago, CNN broke the story that the administration has started to dismiss asylum applications for people who entered the US without authorization and then later applied for asylum. And the report said that these asylum seekers will be placed into this faster removal process for deportation that's called expedited removal. On our end, ASAP has filed a series of requests that's called Freedom of Information Act request, which you may also hear them as FOIA request. And the goal of these requests is to try to obtain more information from the government about what exactly this new policy is, how this new policy will be implemented, and to gauge how many people might be impacted. So we'll share more on ASAP's website when we know more. And I think we are, yes, we've shared the ASAP website in the chat. And
go ahead.
thank you. And just so folks know, we'll also be sharing a couple of other links. If people need to find an immigration attorney, we're going to drop in the chat our link on how to find help resource. And I am also always happy to answer any questions that folks have by email. My email will be in the chat as well, but just in case, it's lady.perez@asylumadvocacy.org, or you can always email info@asylumadvocacy.org, and all of that should be in the chat.
Thank you so much, Lady, for providing a legal overview of the alternative statuses and making yourself accessible to everyone. Really, really appreciate it. So we will now dive into answering some of your questions, moderated by my colleague, Krista.
I want to thank you both so much for the wisdom that you shared with us. Thank you for providing the legal overview. And now I'm going to post some questions that we received both at registration and live using the Q&A function. Because you both are policy experts in your own right, I'd like to pick both of your brains, starting out with Lady, asking, we've gotten the question here live, when someone's TPS status ends, does their work authorization immediately end as well? For example, TPS for Nicaragua ends on September 8th, but this person's EAD card said that work authorization is valid through November of this year.
Yeah, so unfortunately, that is the case, where once the TPS has been terminated, people's work authorization are presumably also terminated. I think there is a lot of arguments that people are making in lawsuits around that, but for the most part, we should all be assuming that if Nicaragua's TPS protections ended on September 8th, that those work permit cards for Nicaraguans will also only be valid through September 8th.
Okay, thank you. And I wanted to make one more note on TPS designations. I wanted to note that our slide previously had a typo, that Ukraine TPS will be valid until October 19th, 2026. So that's what you shared, Lady, verbally, but our slide had a typo, and I wanted to make sure you all registered that. Another question that we've gotten in many different forms live during this event has been around green cards. Folks have asked whether, and perhaps this might be to Manpreet, but for both of you, folks have said they were expecting their green cards, but there seems to be a delay and they're uncertain whether they're still being processed. Would it be appropriate for folks who maybe expected a green card to contact their constituency services office, or what should they do in the meantime?
Absolutely. Thank you for the question. So we at welcome.us have a contact your rep guide. If someone is able to provide that, or we can share it in our follow-up. Our contact your rep guide talks about ways you can contact your rep on your specific case. And for a green card application where it is delayed, this is the perfect example to contact your rep to see if there is a processing delay or a processing holdup. And what they will do most likely is ask you to fill out a privacy release form, and the newcomer will have to fill that out. A sponsor can't fill that out for them. The newcomer will fill it out, send it back to the office, and the office can do a congressional inquiry to see what is happening with the application. Now, I will say this with the caveat that it may not render an answer or a result, but it is one way we can at least try to check to see what the holdup is on a green card application. Lady, did you have anything else to add there?
Only that if for some reason you go to your House of Representative member and that doesn't work, that there's always the Senate office that you could go to. So just make sure that you're availing yourself of, and that the newcomers availing themselves of all options. Thank you, Manpreet.
Thank you both. And we've got another similar question, particularly around Afghan refugees. So this person says, we've heard that all green card applications for Afghan refugees who have been settled in the US are on hold and not being processed. They want a ground truth. Is this true? And even then, should they still go ahead and submit their applications, even if the processing is on hold?
So yes, I believe it was April of this year, the US government has temporarily paused the processing of green card applications for some refugees and asylees, citing the need for enhanced security vetting. And because of that, obviously, folks who have applied for asylum or have applied for green cards have not been receiving them. And I do think that there is no concern to still apply for a green card. That does not mean that you are in any sort of harm if you still apply for a green card, even though there's a pause, because once the pause is lifted, the assumption is that they will start processing those applications.
Thank you, Manpreet. Lady, back to you. We heard from you about kind of an interpretation of some of the policies around that have come out through the HR1 bill that was recently passed, and particularly fees associated with asylum applications and other immigration applications. Can you tell us, are those fees retroactive to those whose applications are already pending right now?
To the best of our knowledge, we believe the answer is no, but there has been no guidance that the government has released since this bill was signed into law on July 4th. So I think we are all anxiously awaiting for their interpretation of the reconciliation bill. But our understanding up until this point is that the fees will not be retroactive and that they will be applied at whatever point both USCIS and EOIR, the immigration courts, update their fee schedule in order for people to actually be able to fee in or to pay for these applications.
I see, thank you. And as you get that clarity, is that something that folks can go to your website to see?
Yeah, absolutely. I think there'll be, once there is guidance from the government, we will be updating for our members. So we will certainly have that updated on our website.
Fantastic, thank you. And also want to plug Welcome. We also have policy explainers to just make those interpretations a little bit more accessible to folks as well. So I would say stay updated on ASAP's website, which is in the chat, as well as welcome.us's policy updates page as well. Those are trusted resources for anyone who's kind of seeking an interpretation. Okay, this next one is for you, Manpreet. This is again back to humanitarian parole. Can a Uniting for Ukraine beneficiary employed with extraordinary skills transfer her humanitarian parole status to a work visa when that humanitarian parole expires?
That is a little tricky, Krista. So the USCIS policy manual essentially says that someone in the US with humanitarian parole status isn't eligible for employment-based adjustment of status, which is what it would take to get a work visa for a Ukrainian with humanitarian parole. Although it may be possible to file an application, it is unlikely it would get approved if the Ukrainian is already here with humanitarian parole or even TPS as their primary status. However, you should still consult with legal counsel to determine if a work visa is a viable option for your newcomer. For more information, I encourage you to check out the explainer developed by the Ukraine Immigration Task Force, and we're dropping their information in the chat below.
Thank you, Manpreet. Another question for you. Someone who registered for this event said they'd sponsored over 10 people from Ukraine and asks, will I be held responsible for repaying public benefit use?
Thanks for that question. So the bill, which outlines an expiration for public benefits for many newcomer populations, applies to future uh, access and enrollment starting in 2026 and 2027. So newcomers and their sponsors will not be required to repay public benefits that newcomers have already accessed, but they will not have access to benefits starting on the dates respective to each of their programs.
Thank you. Lady, this one is for you. This person says, my Ukrainian friends they're here in the United States under humanitarian parole and recently applied for re-parole and completed their biometrics. Is USCIS now processing this?
Yeah, so currently USCIS is not accepting new re-parole applications for Ukrainians via that big streamlined process. So decisions for Ukrainians who applied for re-parole through their USCIS portal after October 2024 may be delayed unless the Ukrainian re-parole process resumes. However, humanitarian parole as a whole has not been eliminated. It's provided by statute, so Ukrainians seeking re-parole can still apply through those traditional methods, so by filing Form I-131 with all of its necessary documentation. And so the key difference is that each re-parole request will be assessed individually to determine if a grant of parole is justified.
Thank you, Lady. And I would add, since this case specifically, they said they've already applied for re-parole, I think this would be another case that you could take to your constituency services office to file that personal form that Manpreet mentioned, because you'll already have like a case number and everything that your representatives could follow up on your behalf with your permission. And again, that guide for how to do that is in our chat for your access. We are going to pivot now away from humanitarian parole pathways to U.S. RAP and U.S. refugee admissions, and particularly the private sponsorship pathway. Manpreet, can you tell us, are families that were already processed through U.S. RAP or the private sponsorship Welcome Corps program, have they been transferred to other resettlement pathways?
Thanks, Krista. And I know that's an important question. And I 100% recognize all the Welcome Corps sponsors that are on the call today. So refugee cases that have already been referred into US RAP through a certified Welcome Corps application currently remain in the pipeline, though their processing is on hold and no flights are being scheduled for these refugees. So if your Welcome Corps application was certified, an email was sent to your group coordinator at the time of the certification. However, if your Welcome Corps application was not certified, the refugee named on your application do not have a US RAP number. This means they have not been referred to the US government for private sponsorship and therefore do not have a refugee case with the US government. Following the termination of Welcome Corps on February 6th, refugees will not be referred, unfortunately, to US RAP through the Welcome Corps program moving forward.
Thank you, Manpreet. I would add, I'm also seeing a considerable number of live questions that are case specific. And so it's without having more information and without being practicing, attorneys, it's difficult to answer very specific and we can't give legal advice. So I would recommend for folks, particularly those who are supporting people abroad, to consider getting a credible immigration lawyer involved who can be able to go and really pour over all of the details of the case, because every case is very nuanced and particular. So I want to say that we see your questions and our heart goes out to those circumstances, and we recommend taking a look at some legal support for those. Manpreet, this is a question for you around Afghan SIV holders. How are SIV or green card holders who are here in the US impacted by the passing of the reconciliation bill?
That's a good question. So SIV holders are admitted to the United States as lawful permanent residents. So given their status, they are not impacted by the immigrant benefits portion of the budget reconciliation bill that was passed earlier this month. But given that they are lawful permanent residents, they may be affected by other aspects of the bill that are not related to their immigrant status or immigration. So we would defer to other advocacy orgs that are speaking to the bill largely on those benefit pieces.
Thank you, Manpreet. And you might have the same response to this question, but it just came through again related to that bill that just got passed. Does this bill make any changes to the exemptions that certain statuses like refugees have to the ban on receiving public benefits as a green card holder?
If they have received their green card, and if is that how I'm interpreting it?
That's
If
right.
yes, if they have received their green card, then they are not affected by the public benefits piece of the bill. If they still have refugee status, they could be affected.
Thank you for that clarification. This question's for Lady. Someone asked, what should my friends do if their EADs based on asylum have been pending for more than 30 days?
Yeah, so there is a lawsuit that we've been a part of, the Rosario lawsuit, but there isn't like one specific thing that you could do. You can flag it for the American Immigration Council, who's lead on that case, or if that person is an ASAP member, they can flag it for us, and we are tracking that the government doesn't sort of en masse do away with their 30-day processing uh, obligations.
Thank you. Um, and I think you've answered this question, but it's been asked in a slightly different way. So I want to make sure folks really understand and are able to kind of have this conversation with you, Lady, while we got you. If someone applied for an alternative pathway like TPS or asylum before July 4th, so that's before that bill was signed into law, will they need to pay the new fees for their applications?
I think that's a great question, and one that we're all waiting for an answer for. They should not have to, given that they have applied for these statuses ahead of the bill being signed into law, but we just do not have the guidance from the government right now. So we do not know how they are either interpreting or implementing. But my sense is that it's going to start to apply for people who apply for any of these statuses after that guidance has come out. So I just don't have anything to point you all to right now.
Thank you. So we're going to stay tuned on your website and on the welcome.us policy updates website for more information on how that new policy is being implemented. We've got a question that asks, they propose that there are a lot of rumors around a bill called the Ukrainian Adjustment Act of 2025 in the community that Ukrainian humanitarian parolees might have a green card pathway. Have either of you heard about this, or do you have any recommendations on that?
Yes, thank you. So we are aware of the Ukrainian Adjustment Act. It's similar to the Cuban Adjustment Act that folks who arrived through CHNV have been able to gain lawful permanent residency here in the United States. We are tracking this bill, and we encourage sponsors who are utilizing our Contact Your Rep guide to advocate for bills and legislation that they support, and contact their rep to see if they are a sponsor or encourage them to become a sponsor, including whether it's this bill or other initiatives to protect individuals here through the programs like Uniting for Ukraine and CHNV to provide an opportunity for them to live and work here as well.
Thank you, Manpreet. Someone just noted in the chat, my Ukrainians applied for parole extension on January 15th for an expiration date of July 15th, and their USCIS portal has dropped the time needed to process from 2 months to 1 month just recently, I imagine. So they might seem to be processing extensions. And to that, I'd say, please keep us updated. This is coming just from someone who's on our call right now. And this is the kind of information and ground truthing and sharing that we'll be able to do in these welcomer communities that we've launched too, just to hear from your real experiences, because we hear from the experts who are expert at interpreting policy, but we've also heard that the government is also interpreting its own policy, and there's a lot that we don't know. And a lot of what we do know is from folks like you who are experiencing delays or things that are moving forward as well. And so that's why we want to connect you with each other to really grow the amount of knowledge, information, and network that we have. So I really thank you for sharing that. We've got one more question, and this is another one about the congressional representative inquiry that we mentioned. Someone asks, can asylum applicants also use that inquiry to follow up on applications?
Yes. If you have any pending immigration application, you are welcome to contact your member of Congress or your senator, and they will again direct you to fill out a privacy release form where you can put in your information and then they can do a congressional inquiry. So yes, for any immigration application, you are 100% welcome to contact your representative.
That's just fascinating. Thank you so much, Manpreet, and thank you, Lady, for joining us today and for offering your expertise to our community of sponsors and welcomers. And thank you for all your efforts supporting newcomers as they navigate what I'm learning is an incredibly complex and dynamic policy environment. And we're so grateful for you spending your time with us today and sharing your expertise. And we've shared a lot of resources today, such as the new HR 1 policy explainer and additional considerations for sponsors and newcomers. We'll be including those resources and a recording of this webinar in our post-webinar email. And I encourage you to take a look at that. And if you're a sponsor or welcomer in one of our welcomer community launch states, I'd also encourage you to consider joining us for that. We convene monthly Zoom meetings for you to meet other sponsors, and also it gives you access to a whole network of welcomers right at your fingertips through our WhatsApp group. If you'd like to explore more, please complete the quick interest form, which we'll be dropping in the chat. And this link will also be in our post-webinar survey and in the post-event email that you'll receive in the coming days. But if you don't live in a state where we've launched a welcomer community just yet, but you're looking for ways to get involved, consider taking a look at our map of local organizations accepting volunteers. This isn't an exhaustive list, but clicking the link in the chat is a good place to start. And of course, I hope you'll join us for the next Welcome.us at the Table event on Thursday, August 21st at 3 p.m. Eastern. This will be a special event in remembrance of our Afghan allies, and we'll hear from partners Afghan EVAC and No One Left Behind about how they continue to serve and support Afghans at home and abroad. And you can register by clicking the link in the chat or in the follow-up email. Again, a huge thanks to our special guests, Kim and Lady, for sharing their wisdom with us. And thank you so much for joining us today. It means a lot that you chose to spend the last hour with us, and I hope you found it helpful. I look forward to seeing you back here at the table on August 21st. And until then, be well.